Now let's go to classification of employees. We will start with Article 295 as our basis. Article 295 dictates that the provision of written agreement to the contrary notwithstanding, regardless of the oral agreement of parties, an employment shall be deemed regular where the employee has been engaged to perform activities which are usually necessary or desirable in the usual business or trade of the employer. In other words, regardless of whatever contract or the terms and conditions of the contract entered into by the employer and the employee, as long as the nature of the services by which the employee is engaged is usually necessary or desirable in the usual business or trade of the employer, the employee is deemed regular even if they agreed in the contract otherwise. What do you mean by usually necessary or desirable in the usual business or trade of the employer? The Department of Labor usually describe it as relevant or related to the usual business or trade. What are these activities that are related? When you talk of a bank, the job of a tailor is necessary or desirable. When you talk of a school, the job of a teacher is also necessary or desirable. Therefore, when we say the job is necessary or desirable, it means that if you take away that job, the corporation or the entity could not exist or function. All other jobs that are not necessary or desirable can be subject to labor or legitimate job contracting. However, if the employee is performed to engage this kind of job on the first day of employment, the employee is considered regular unless the employee or the employment falls under the following exceptions. So what are these exceptions? When the employment is considered project employment, when it is casual employment, or seasonal or fixed term employment. So the reason why the contract will not prevail over the provisions of Article 295, because in the case of Innodata Knowledge Services Incorporated versus Inting et al., December 6, 2017, the Supreme Court ruled that employment contract is vested with public interest, and therefore the contract must yield to common good. So it is very important that the labor contract is placed, according to Supreme Court, as regards status. It is placed higher than all other ordinary contracts, and therefore subject to the power of the state. So therefore, no parties can stipulate the employment status of a person through an employment contract that would go against Article 295. So if you agree, if employer and employee will agree that the employment is casual, but in reality, the employee is engaged to perform activities which are usually necessary or desirable in the usual business or trade of the employer, then the employee is deemed regular by law. The agreement of the parties pertaining to casual employment will not prevail because the contract is null and void. It is against Article 295. So when you say regular employment, the employee here is engaged to perform an activity that is very important to the employer. And for that reason, since the employee is performing an important job to the employer that cannot be dispensed with, it is but natural that the employer will exercise control over the conduct of the work of the employee. So that's why even supervised piece rate employees become regular employees, because they perform activities that are necessary or desirable in the usual business or trade of the employer, and there is also control. So it necessarily follows that if the employer controls over the conduct of the work of the employee, then the employee is the activity by which the employee is engaged to perform is necessary or desirable in the usual business or trade of the employer. So in the case of Mark Roche International versus NLRC, August 13, 1999, that has been the ruling of the Supreme Court, that supervised piece rate employees can become regular employees. Another important thing that you have to remember, the case of Isidro Quibral versus Angbos Construction et al., November 7, 2016. This was the case of project employment. According to Supreme Court, in the absence of employment contracts, when it comes to project employment, the employees are deemed regular employees and can only be dismissed for just or authorized causes. So that's the essence of regular employment. Always remember, it is not the period, the number of days, which is the basis for the determination of whether the employment is regular or not. It is the nature of the activity by which the employee is engaged to perform. Okay, let's go to the next classification of employment. We are now talking of the exception to regular employment. Let's start with the first exception, the project employment. This is an exception to regular employment, and in this case, the employee is performing an activity which we call project. There is a specific project or undertaking wherein the duration and scope of which have been specified when the employees were engaged. In the case of Wilfredo Arro et al. Versus NLRC, March 7, 2012. If you are going to engage the services of an employee or project employee, there are things that you have to remember. First, we have to reduce the employment contract into writing, although the law is not explicit about it. But the ruling of the Supreme Court will tell you, as what I have mentioned earlier, in the case of Quibral versus Angbos Construction, that if there is no employment contract, project employees will become regular employees. So as the employer, there are things that you have to remember when you enter into project employment contract. First, reduce the contract into writing. Second, in the contract, it must be specified the nature of the project, the scope of the project, and the date or the duration of the project. Secondly, the employee must be appraised of the contract, the terms and conditions of the contract. The employee must know the nature of the project, the scope of the project, and same time the duration of the project. And finally, under Department Order 19, after the termination of the project, the employer must notify the nearest Department of Labor office for the termination of the project. Otherwise, if you don't do this, then the employees will not be considered project employees. We have to take note that the Supreme Court has identified two kinds of project employment. In the case of GMA Network Incorporated versus Carlos Pabriga et al., November 27, 2013, The Supreme Court discussed that there are two kinds of project employment. The first type of project employment is when the employer engages the services of the employee and these employees perform or are engaged to perform activities that are usually necessary or desirable in the usual business or trade of the employer. These refer to construction companies. The nature of their business or the activity that the employee is engaged is related or relevant or what we call necessary or desirable. So they hire construction workers. Now this is the first type of project employment. The second type is when the employer undertakes a job undertaking not within its regular business or regular course of business. When you say not in the regular course of business, meaning you are not a construction company. You are a corporation or a company who wants to build something or like some sort of building. Then you will hire employees in order to construct that specific project. That construction of specific project is not within the regular course of your business. And when you engage those employees, these employees are not performing activities that are necessary or desirable in the usual business or trade of the employer. But this is considered project employment. So let's now go to the complication. Remember, I mentioned earlier that the project employment contract must be in writing. So what will happen to the first type? The first type of project employment where the employees are engaged to perform activities that are necessary or desirable in the usual business or trade of the employer. If there is no written contract, first, citing the case of Inadata, if there is no written contract, no, not Inadata, Isidro Gibral I mentioned earlier. If there is no written contract, then in the first type of project employment, the employees become regular. Another instance is when the employees are continuously rehired after the termination of the project. What do you mean by continuous as opposed to intermittent? So when the employees are continuously rehired, it means that immediately after the termination of the project, the employees now are assigned to another project belonging to the employer. In that case, there is what we call continuous rehiring. So if that happens, then the employees are considered regular employees, because the act of continuously rehiring the employees would show that that is not project employment anymore. It would show that the employees have become regular because they are needed by the company. So those are the instances when project employees under the first type will be considered regular employees. You take note of the case of MacArthur Malikdim and Hermenegildo Flores versus Marulas Industrial Corporation and Mike Mancilia, February 26, 2014. That will tell you of the project employee becomes regular because of the continuous rehiring. So if you don't want your project employees to become regular, do not hire immediately. So you have to put a period wherein the employees will stop working and then assign to another project. So what will happen to the second type of project employees? These are project employees who perform or who are hired to perform a job or undertaking not within the regular business of the corporation. In other words, they perform activities which are not necessary or desirable in the usual business or trade of the employer. What will happen if there is no written contract? So if there is no written contract, they will be deemed casual employees. The project will not be appropriately called project, it will be considered activity. So as long as the activity is existing, then the employees cannot be terminated. So instead of declaring them as project employees, in the absence of written contract under the second type, they will be considered casual employees. Another instance is when the project contract is vague. When the project employment contract is vague, the employee is deemed casual employee. You have the case of the University of Santo Tomas versus Samahan ng mga Gawa ng UST et al. April 24, 2017. Another thing that we have to remember when it comes to wage increase, in the middle or in between the duration of the project, in the middle of the implementation of the project, assuming that there is a wage increase, what will happen? Under Department Order number 19 series of 1993, the wage order will be implemented and the contract between the employer and the contractor and the principal shall be deemed amended, and then the contractor will pay the employees of the wage increase subject to refund by the principal. Regarding the submission of report upon termination of project employment, since it is required, if the employer cannot comply, it will give rise to presumption that the employees are not project employees. On the other hand, even if there is submission of report to the DOLE, but there is no project employment, the employees are deemed not project employees. They are deemed regular employees. In the case of Kibral versus Angos, Construction Incorporated. So those are the things that you will remember when it comes to project employment. Do not forget the necessity of reducing the contract into writing. Another exception to regular employment is seasonal employment or seasonal employees. When you talk about season, we usually refer to a period of the year characterized by or associated with a particular activity or phenomenon. Like for instance, when you talk of rice production, there's the season for planting, there's a season for harvesting. So employees may be hired during planting and during harvesting. In between season, according to Supreme Court, the employees are temporarily laid off in the case of Philippine Tobacco Flow Curing and Redrawing Corporation versus NRC November 10, 1998. In between the season, the employees are temporarily laid off and there's no obligation with the employer to pay wages, applying the principle of fair day's wage for fair day's work. In between season, it will not prevent the employee from finding alternative source of employment. However, when the season returns, there is the obligation of the employer to rehire the employees, and also the employees must return. If the employer will not rehire the employees, then there will be illegal dismissal without any valid reason. On the side of the employees, if the employee will not return to work then the employee is deemed to have abandoned work. So there will be gross and habitual neglect of duty as a just cause for termination of employment. So when it comes to security of tenure, the seasonal employee can be terminated based on just or authorized causes, subject to due process. When it comes to project employment, if you compare seasonal employees from project employees, seasonal employees can be terminated only based on just or authorized causes, because after the season they are not terminated, they are all temporarily laid off. If you talk of project employment, they can only be terminated based on just or authorized causes and the completion of the project. No need for written notice because the expiration of the period has been predetermined upon engagement of the employee. All you have to do is report to the dole. Let's go to the exception, another exception, casual employment. Casual employment is the last exception prior to the fixed term employment. If it is not covered by the preceding paragraph according to 295, which means that it is not regular, project or seasonal, you must be casual employee. Provided that any employee who has rendered at least 1 year of service, which service is continuous or broken, shall be considered a regular employee with respect to the activity in which he or she is employed, or her employment shall continue until such activity exists. However, according to Supreme Court, the characteristic of casual employment is this. The employee is engaged to perform activity that is not necessary or desirable in the usual business or trade of the employer. In other words, the employee is engaged to perform activities or activity that is only or are only incidental to the business of the employer. So you will hire these employees, and as long as this activity exists, you cannot terminate unless there is just or authorized cause. So if the employee has rendered at least 1 year of service and the activity still exists, according to 295, the employee is considered casual employees. However, the core of the article regarding casual employment is about the nature of the activity. As long as the activity exists, then the casual employee cannot be terminated. If the activity ceases to exist prior to 1 year, it's the same thing, the employee can be terminated. After the expiration of 1 year, and if the activity ceases to exist, then the employee can also be terminated. So we cannot use 1 year as a basis for the relative security of tenure of a casual employee. The security of tenure of casual employee depends on the activity. As long as it exists and there is no just or authorized cause, the employee cannot be terminated. The question now is this: can you predetermine? Is the period definite when it comes to engagement of casual employees? The Supreme Court answered in the affirmative in the case of Amar Conte and Leopoldo Cruz vs. NRC, April 10, 1997. In this case, the Supreme Court said that this casual employment where an employee is engaged to perform a job, work, or service which is merely incidental to the business of the employer. And such job or work or service is for a definite period made known to the employee at the time of the engagement. So the question now is this activity really definite as to the period? Can you approximate the completion of the activity? Yes. However, it is not safe if you fix the period because you may not be able to finish it within the prescribed period. So if you fix the period of the activity for 1 year and the activity is still existing beyond 1 year, you cannot terminate the employee based on the period. But it doesn't prevent the employer from fixing the period. The employer can approximate the period. After all, it doesn't matter. What matters is the existence of the activity. So it is the activity that is very important. However, we have to take note of the case of University of Santo Tomas versus sama ng mga gawa ng UST. I mentioned that earlier. What will happen if these casual employees are rehired? According to the Supreme Court, these casual employees are still considered casual employees even if they are rehired because the activity still exists. It will create a danger because with this kind of ruling, it will allow the rehiring of casual employees. So if you will be asked with this question, can you rehire casual employees? Yes. Cite the case of University of Santo Tomas versus Samahan ng Maragawa ng UST. Although it is not a good ruling, because if you allow this one, you will allow employees to become casual forever. If you repeatedly rehire a casual employee, it would show that the activity by which the employee is engaged to perform is necessary or desirable to the usual business or trade of the employer, and it will be a circumvention to security of tenure. However, there is still the ruling of the Supreme Court, so this ruling will prevail, and you use that in your bar examination. Again, you can rehire a casual employee because the rehiring doesn't mean the indispensability of the activity. It only means that it is necessary. So as long as that activity exists, then you will be considered casual employee, and the hiring and the rehiring of that employee is valid